This is a sad case, of course. As one of your fellow jurors commented during the jury selection process, a young man lost his life, another is fighting for his. There are no winners here.
It's a case that has reopened old wounds and prompted a national debate when it comes to racial profiling. All eyes were on Florida today as the opening statements began in the Trayvon Martin trial. And Dominic Carter, he joins us again with the latest.
Well, Richard, proceedings are over for the evening as day one is complete. An intense start to opening statements.
Punks. These assholes, they always get away. Those were the words in that grown man's mouth as he followed in the dark a 17-year-old boy who he didn't know.
George Zimmerman accused by the prosecution of targeting Trayvon Martin in February of last year when he shot the unarmed 17-year-old to death in this neighborhood in Sanford, Florida.
George Zimmerman did not shoot Trayvon Martin because he had to. He shot him for the worst of all reasons, because he wanted to.
The defense up next, starting with an ill-received knock-knock joke.
Knock, knock. Who's there? George Zimmerman. George Zimmerman, who? All right, good. You're on the jury.
No laughs from the jury of 6 women. They then heard and saw some of the evidence the defense plans to lay out. Zimmerman's attorney saying they'll prove he was attacked by the teen and acted in self-defense.
Trayvon Martin armed himself with the concrete sidewalk and used it to smash George Zimmerman's head.
The 911 call in which someone is heard screaming out for help played twice today.
So you think he's yelling help?
Yes.
All right, what is your opinion on that?
It will be up to the jury to decide whose voice that is, and ultimately, the fate of George Zimmerman. He could face a maximum of life in prison if convicted. His trial is expected to continue as long as a month, Richard.
Thank you, Dominic. You mentioned last week when I wasn't here the significance of that audio tape before we even get to opening statements. And as we mentioned, it was ruled that you're not going to have expert testimony as to whose voice it is. So they'll hear the voice, they'll hear it, but it's going to be left to the jury to decide who's screaming help, right?
Yeah,
and that certainly helps the defense, I assume.
It does help the defense. I mean, look, I'm not privy to the discovery in the case. Nobody's privy to what the evidence is. But the evidence seems pretty scant, and I think that expert testimony was an important piece, and I was mildly surprised that the judge kept it out because the state evidentiary standard for admitting expert testimony is quite low, even though it was painted by the defense as junk science. So I was surprised. It was a pretty gutsy ruling one way or the other.
Now, you've been before the high court here, so you know about some pressure situations. I understand it's pressure, but what exactly was the defense doing with the knock-knock joke? It's the stupidest thing I've ever seen.
Well, you know, it's odd because they have a very high-profile jury consultant, the Hirschhorn firm. So there have been focus groups convened by the defense, mock arguments given. Make no mistake, this has been rehearsed and rehearsed and rehearsed. And what you have going on here is a very strange role reversal. You have a prosecutor who's acting with a lot of dramatic flair, more like a defense lawyer, and a defense lawyer who's acting academically, very prosecutorially, in a very dry kind of way. This is no doubt deliberate. It's totally counterintuitive. I'm not sure why they're doing it, but you know that this has been focus group tested, and this is deliberate strategies that both sides have settled on.
In the end, Dominic, what do you think this trial is going to be about?
Wow, that's a good one. If you're an African American, this trial is about a teenager walking with Skittles, or if you're a progressive or a liberal, whatever, it's going to be about a teenager walking with Skittles and an iced tea, and the 911 tape, as was played today. I mean, no, we don't need you to follow him, and he did it anyway. I mean, I guess everyone's going to look at it from that part. I agree the evidence may be a bit weak, but I don't think this is going to be judged on evidence. This case will be decided on emotion. Whichever attorney can get across
Pray
bets.
that's not the case.
If that's the case, Zimmerman's going down.
Pray that's not the
If
case.
that's the case, Zimmerman's
We don't
going
do you
down.
think
want
it's about?
verdicts brought because they
Yeah.
like or they dislike
It happens
either
every
the
day
plaintiff.
in the
I
courtroom.
didn't say it didn't happen. I said it's not a good thing. The
Okay.
fact of the matter is that people are going to head into this with preconceptions. The real question is, does the jury do that? And the question here is, what do we want the jury to do? We want the jury to listen to the evidence, remember that there's a presumption of innocence, and make a judgment about whether there's a reasonable doubt. I don't know enough about the evidence to have a strong an opinion as Dominic does, but that's what we
It's
all
one of those
want.
unique cases where there's no debate about that he fired the gun that night. There's no debate that he was on with a police dispatcher. There's no debate that Trayvon Martin wasn't carrying a gun that night, and there's no debate that Trayvon Martin didn't have a reason for being there that night. It's almost like we know before we go into it what happened, but we don't really know, and we won't know at the end.
We're never going to know what happened.
You know, who yelled help and whatever else. It's a bizarre kind of
So
set of
let's remember that
circumstances.
Florida has the no retreat law. So if you believe that your life is in danger, you have the right to use deadly force. So the question is, did Mr. Zimmerman believe he was in danger enough that he
But
had
it's
to use
not,
that
it's
deadly
not
force?
only that, because before you get to that, the belief, no matter the standard ground law, has to be a reasonable
Reasonable,
belief.
yes.
And nobody in 2013, as I've said before, is going to think it's reasonable to be afraid of somebody just because of the color of his skin or the fact that he's wearing a hood. There had to have been a physical threat, an actual physical threat by this young man in order for the fear to have been a reasonable one. And that's going to be
But
the
here's
hard
my
thing.
question.
but
It
there
really
is a-
seems the crux of it is, who knows? But you almost see this, that this numbskull gets on the phone. They tell him don't. And whatever baggage he brought with him, he still pursued it. He gets in too deep and he realizes, as the kid approaches him, wait a minute. And then we don't know what happens from there.
We don't know.
If he put himself in the situation or created the situation, does it matter what happens after that?
I think it does matter what happens after that, because if as it's been spun in the media, that he tried to turn around and get away from it, what matters is his state of mind in the instant before the crime occurred.
Let me ask a lawyer's
Yeah,
question
yeah.
that will explain. What are the lesser includeds here? That is, that for your non-lawyer
Yeah.
viewers, what could the jury convict him of short of manslaughter or murder?
That-
Murder in the second
that-
degree is being tried
That's right.
for.
I have always thought that if there's going to be a conviction here, it would be on some sort of charge down theory. I don't know what the
Manslaughter?
some sort of manslaughter, some sort of lesser
Reckless
included
endangerment,
offense,
something like
something like
Can you
that.
do that
But
under
Richard,
Florida
I
law?
think you
But-
can do that, but the
Richard-
sides will have to make a tactical decision at the end whether they want the lesser included offenses charged and whether there's an evidentiary
Richard,
basis for
The
charging.
black
lesser
community
included
has
offenses.
dealt with lesser included charges for the last 20 years. In Bensonhurst, with Howard Beach, Michael Griffith, Yusef Hawkins, all the time lesser included charges by high profile prosecutors like Charles
And one other
Hines.
thing, the two most
Anything-
important people in this trial, I don't think, are the two attorneys.
Donald,
It is the Martin
What's your name?
parents who, to me, if they've come across here as the most reasoned and sympathetic
That
people
has
of this
nothing to do
entire
with
case,
nothing.
oh, I think it has everything
Do
to
you
do
remember
with
the Central Park jogger case?
Yes.
People were sure they were guilty.
Yes.
Were they guilty?
Like Donald Trump.
Were they guilty?
According to what the evidence says, no.
Were they convicted?
Of course.
Would you wish that on anybody?
What
No
I wish.
no further
no,
questions.
No,
No,
wait,
you
wait,
didn't
wait,
prove
wait,
it.
wait, wait,
You
wait, wait. I don't understand. Would I wish that on anybody?
Would you wish it on George Zimmerman?
Would I wish that Mr. Zimmerman be convicted?
If he
That's
didn't
not.
do it.
If he didn't do it.
Well, he did it. The
Okay, well,
question
wait a
is
minute.
what he did.
But here's the problem. Here's the problem. Let's reverse this for a second. Richard, I know
Dominic,
we got to
make
take a
it
break.
quick, 'cause,
Okay,
yeah.
so a black guy's on the phone with 911. Sir, don't pursue him. We don't need you to do that. The black guy pursues the guy anyway, and the guy is shot. What do you think happens?
I think Central Park joggers were convicted because there was a climate that said they're guilty.
But wait,
And the
Richard,
evidence was
Richard,
ignored.
there's only one
Don't
problem-
let that
And
happen
the only
again.
problem with your
Bernard
theory
Goetz
is
also.
Right.
Remember Bernard
Goetz.
Goetz?
That's
Zimmerman
right.
pulled the trigger. Zimmerman was on the phone.
Don't do that. Don't follow
You-
him.
to suggest those kids didn't commit.
I don't know that George Zimmerman didn't do it, and I'm not.
He acknowledged he did do it.
Hold it. I am not coming out for an acquittal. What I'm saying is, when you have smart people say he did it, I know it, and we want him convicted before you hear the evidence, you'll run into some tough situations like the Central Park jogger case.
We're going to take a break here. We went so over. I'm going to figure out what we're going to talk about right after the break here. Stay with us. We do have an update, though, on stop and frisk we want to get into, as race in America seems to be a dominant theme this evening. Stay with us.